to chat a little bit more about this. Let's look at what this all entails from a legal standpoint. Fiduciary Attorney Zola Mbatha is here in studio with us. Zola, thank you for your time at this hour.
That's good.
We were privy to listening to this package and then obviously discussing offline. And you mentioned that the crux of this is really due to the systemic failures of lack of planning, lack of estate planning.
100%.
Let's backtrack a little bit. Let's just look at the impact that the Apartheid era laws would have had on black women in relation to property rights, how that is still playing out in modern day South Africa and constrains the system at large.
Yeah, so thank you so much. It's lovely being here with you today. And I'm happy we're having this discussion because of the work I do in the communities. And I actually deal with something like this every time I'm in these communities. So let me try and break it down to you like this from a summary perspective. The act that they are referring to and that has impacted this Gogo is an act called the Black Administration Act. This is a 1927 act where only men in the black communities could own property. This act has been repealed small by small over the years. I personally don't think the issue is the act, Black Administration Act. Too many things went wrong during apartheid. It was designed for things to go wrong. And it was so systematically designed that even after liberation, where the government is handed back to the black people, those systems and those acts still make things go wrong for black people. However, in South Africa, we have a beautiful constitution, as they call it around the world, the most beautiful constitution in the world. Now, with this constitution, it came with what is called fairness, the principle of fairness. And with this principle of fairness, they then said, we erase whatever apartheid laws that existed. We are now operating as equal people. And therefore, what replaced the Black Administration Act is an act called interstate succession, which is what's affecting Gogo more than the Black Administration Act. And I say this because the Black Administration Act is in the past. We're in the present now. Now, if you understand what I'm saying, it then means from 94, let's be reasonable because the Constitution was 96, reasonably from 96 until 2025, Gogo had a chance to ask her son to revert back ownership to her. So did Gogo's son and Gogo's daughter. And you see, what I'm also picking up here is this cultural issue in the black communities where the makoti, the bride, is treated badly when her husband dies. I personally am seeing there's a family that had almost 30 years to ask for the ownership to be reverted back to Gogo, and they didn't. Now that this man has passed away, the wife, we don't even know how much time the wife has had to grieve. She herself is saying, I did not say Gogo must move out. I'm asking for a period to grieve. And they failed to ask the son to revert back ownership in 30 years, but now the bride, because she's not of their family, they have taken her to the media. So is there an abuse here of the makoti, such as is culturally happening in the communities, or is this makoti unreasonable? She hasn't said Gogo must move out. And Gogo can stay there. Now, let's talk about interstate, which has replaced the Black Administration Act.
Can I also ask you to then explain beneficial ownership versus registered ownership and how that also then plays out?
So interstate answers exactly that.
Thank you.
So beneficial ownership, it basically doesn't have a major play when it comes to property ownership. Property ownership needs to be titled. You need to have a title deed after 94. If the family home pre-94, yes, pre is before. Pre-94, they had ownership or they could use the property based on a document called a permit, because black people couldn't own property. So they were using permits until it was converted to title deeds, and then because of the Black Administration Act, and the act specifically said only black males can own, then it went to the son. This is how the son ended up, because Gogo's husband had passed away. Then when she wanted to take ownership in the late 80s, they said the Black Administration Act only allows a male, so bring your son. So all of that is fine. But after 96, then that's where the conversion of the ownership should have gone from the son back to Gogo. But there's many things that could have stopped that. For example, if you're going to transfer, if you and I, we transfer property amongst each other, there's donations tax. How am I transferring ownership to you? So transfer costs. So perhaps they didn't have the money to do the transfer. But we are here now at the estate. Now, where the son failed his mother, he didn't transfer ownership after 94. 30 years is a long time to save for those costs. Okay, he also got married in communal property. He could have married out of commuter property because he's aware that he owns the family home. And then lastly, where he failed her, in the last instance, he didn't even do a will for his share now, because the incommuter property marriage gives the wife half of the property just automatically by virtue of the marriage, but at least the son still owns half of Gogo's house. He could have done a will, leaving the half to Gogo then, so that the Makoti does not look like she has so much power.
Here's two questions. Would continuous occupation play to her advantage, or even original intent? How does that also then weigh in, given the circumstances?
At face value, not necessarily, because the most powerful thing about property is ownership and the titling of it. However, should Gogo have the means to go to court? Let's say the South African lawyers for human rights. They were to assist Gogo. There was a case last year in October that came out called the Dlamini case, Nomthandoza Dlamini versus Sylvia Dlamini, where it declared that the courts are recognizing that in the communities there are family homes and that everyone must own the family home, and that a family home cannot be sold without the consent of everyone. So should Gogo then rely on that case and ask the lawyers for human rights to represent her? Perhaps there could be an argument in court to get a declaratory order that maybe the ownership should be converted back to Gogo. But in the current format, in the absence of a case, of a court case, it's interstate succession. And interstate succession says, if you die without a will, I take over. And half is already to your wife by virtue of the marriage, and then the other half is going to go based on the value of the property.
And then the municipal records that aren't there as well, that also, the paper trail, I mean, that also must also hinder
there's an area
progress.
called, yes, there's an area called Bramfisherville in Johannesburg. It used to be owned by a mine, this land. And then when the mine finished the minerals and the life of the mine spanned out, they then handed the land back to the government. What the government did was they gave it to the people and they built RDPs on it, but they didn't change the ownership. The property, the land in its entirety is still owned by the mine. That speaks to the municipal records. Gotcha. And that's where the risks come in. Of course, if government is going to be negligent, take it easy, or be slow, things that go wrong are faster than what people, like what the government is catering for currently.
So you've spoken about how common these cases are. Yeah, so there's obviously new conversations that need to be had given the frameworks that exist already, and correcting some of the past injustices, but just ensuring that there's proper estate planning. Yeah, that was the crux of the matter that you highlighted. Yeah. What options are available at her disposal, even for the spouse at large? What precedents is this, can be set through this?
Sure. I mean, I also think, just to quickly mention, there isn't a mention in this entire thing of where is the spouse supposed to go live now. So the law is not necessarily wrong. It's not the law that is the problem. It's the lack of knowledge of the law and the lack of estate planning as a result of not understanding the law or refusing to understand it. There's so many people who are refusing to do wills, not because the will is going to do anything to them, or it's a high risk, or they're going to lose anything, but just because they don't understand it, and when they don't understand something, they shut out. But the cost is too high. That's what is going on here. If this is going on with this Gogo, it's going on with Gogos all over South Africa, and they are losing their homes for multiple reasons you and I can't even discuss because of the time restraint here. But estate planning for the communities is very important. They can start with everyone who has dealt with the death of any form must go to the Master of the High Courts. Master of the High Courts is supportive to them. Should they want to know who the owner is, who the current owner of that property is, they must go to the deeds office. They don't have to blast the Makoti on media. They can go to the deeds office.
Okay, well, Zola, thank you for your time, for unpacking that. Let's see how this obviously all plays out,
let's see how it plays
what precedence is going to be set through it. Zola Mbatha, Fiduciary Attorney, joining us to unpack that case.